And I'm going to begin with introductions. Our very first speaker is the Honorable Daniel D. Angelillo, a retired senior appellate justice and Pace Law School jurist in residence. We are so honored to have Justice Angelillo as our jurist in residence. He follows in the footsteps of judges such as Chief Judge Lawrence H. Cook and Justice Sandra Miller of the Appellate Division. Justice Angelillo served on the bench for nearly 20 years, first as a county court judge of Westchester County and then as a New York State Supreme Court justice. In 2005, Governor Pataki appointed him to the Appellate Division of the Supreme Court, and in 2010, Governor Patterson designated Justice Angelillo a constitutional member of the court. He presided over the Integrated Domestic Violence Court in Westchester County. The court commenced operation in October of 2001 and was the first of its kind in New York State and serves as a model for other domestic violence courts in New York State and the USA. The judge also presided over New York State's first domestic violence felony misdemeanor court. Former Chief Administrative Judge Jonathan Lippman appointed him Associate Justice of the Appellate Term, 9th Judicial District and 10th Judicial District from 2004 to 2006. Former Chief Judge Judith Kaye appointed him to the New York State Commission on the Jury in 2004. Justice Angelillo has served on the New York State Judicial Ethics Advisory Committee since 2011. He's a graduate of Boston College and St. John's University School of Law. And most importantly for us at Pace Law School, he's our jurist in residence, and he begins the program.
Thank you very much, Jay, and good evening, everyone. It's good to see all of you, and thanks for the kind introductions. I want to also thank Professors Carlisle and Halpern and Centone for inviting me. I was a late addition to this program, and I welcome the opportunity to be with you tonight. I've been asked to take a few moments to speak specifically about the CPLR Section 3101, dealing with disclosure, dealing with party and non-party witnesses, and specifically the recent Court of Appeals decision of Capon against Koch, which was decided April 3rd, just a few weeks ago. And that case is in your material. But just first, a real quick aside before we start discussing the case, and that is during the past 4 months, I've had the opportunity to do some consulting work and some of-counsel work in the commercial area and land use as well as matrimonial. And there was one particular case I'd like to mention to you, and that was in February. It was a non-jury trial. It was a commercial case, and I worked with Professor Halpern on that case. I enjoyed the experience tremendously, but I want to tell you how much I appreciated in watching, I was part of the litigation team, watching his level of preparation. And as a judge for 20 years, I've got to tell you how much we as judges appreciate when a lawyer comes into court prepared. And it makes our job that much more enjoyable and also at times even that much easier. Now, at the appellate level, it was rare that you'd have a lawyer appear before you that was not prepared. Unfortunately, at the trial level, it happened a few times. But watching Phil Halpern was really tremendous. I was there watching his preparation, and I certainly have great respect for what he and his team did, his law firm did. I noticed that, this was a big client, and some people might say, well, he had a big client, that's why he did all this work. But no, it was very obvious that whether he was representing a big client or a small client, he was going to give it 110% of that preparation. And being on this team, I was with Phil Halpern. There was also Al Dinellen from DeBello Dinellen, and also Deb Scalise, the ethics expert here in the county. And the attorney from the other side, I think you'll remember this, Phil, he came in the first day and he saw Phil Halpern and Al Dinellen, and Deb Scalise, and I happened to be there too. And he said, then he said to the judge, "I feel like I'm up against the 1927 Yankees." And I got to tell you, I kind of feel that way today. I'm just playing a small part today, of course, but with Professor Halpern, Carlisle, and Centone, that's the way I feel today. And I want to thank them again for giving me the opportunity to join them. So, CPLR 3101, I always like to begin with the statute itself. It's entitled Scope of Disclosure, paragraph A. Generally, there shall be full disclosure. There shall be full disclosure of all matter material and necessary in the prosecution or defense of an action, regardless of the burden of proof, by, number one, a party, or the officer, director, member, agent, or employee of a party, or for any other person, upon notice stating that the circumstances or reasons such disclosure is sought or required. So the opening paragraph speaks of material and necessary, those terms very important. Then in paragraph 4, circumstances or reasons. We'll talk about those terms in a moment, specifically the Koch case. So this amendment, this section's been around since 1984, and prior to the amendment, there was a requirement of special circumstances that must be established prior to disclosure of a non-party witness. So paragraph 1 deals with a party witness, non-party witness, paragraph 4. So the CPL had a distinction, and the distinction was that there had to be special circumstances before the subpoenaed party could obtain either the testimony or records of this non-party witness. And the law, as I said, was amended, took out the terminology special circumstances, and we have what we have here. But then between 1984 and 2010, all those years, we had many, many, many appellate courts, first, second, third, fourth departments, still requiring special circumstances, notwithstanding that the legislature had removed it. And then in 1988, there was a case called Diaguardi from the second department. Now, of course, I wasn't on the second department in 1988, but we had this case in 1988 that required special circumstances, notwithstanding the fact that it had been removed by the legislature a few years earlier. So all these years go by, and many of the appellate courts were still requiring special circumstances, and there were contradictory decisions within the same departments, and that's how confusing it was getting to practice law in this particular area. When were special circumstances needed or not needed? Then in 2010, Cooper comes along, second department. I'm on the panel with 3 other judges. I was assigned to write the opinion in that case, and the court in Cooper in 2010, May 2010, said special circumstances are not required. We took a look at the legislative intent, we reviewed all the prior decisions, and if you have a chance to take a look at Cooper, you'll see we cited many of those cases, and we specifically said that special circumstances or any cases that required it will no longer be followed. And that was in 2010. Now, when Cooper was decided, we took a look at the statute, and we said, well, in paragraph A, it talks about material and necessary, and paragraph A4, it speaks of circumstances or reasons. You must put on notice stating the circumstances or reasons such disclosure is sought or required. So we, in viewing that, felt that there was something more that was required than just material and necessary. So we made that ruling in 2010. The third department agreed with us. However, the first and fourth departments were going in a different direction, saying that all that is necessary is material and necessary, matter that is material and necessary, and then you can have disclosure of a non-party witness. Basically, making no distinction between the two, between a party and a non-party, other than, of course, there's this notice requirement that on the subpoena you have to put on the notice the circumstances, the reasons that you want this disclosure. So you either put it in a notice or you put it right on the face of the subpoena. First department and the fourth department said that was all that was necessary. Second and third department, we required a little bit more. And I'll get into the reasoning and the thinking of the court and why we did that, and some of you may even agree that it was necessary, but we'll get to that in a moment. So clearly, we set aside DiAguardi, May of 2010. 2 weeks later, I'm at the Westchester County Bar Association annual banquet. Now, many of you know that we're going to have our annual banquet here in the county in a few weeks. Well, 4 years ago, it was also in May of that year, 2010. At the cocktail hour, I enter, I see my good friend Jay Carlisle. We've known each other for 30 years. Big smile on his face, he comes running toward me, shaking my hand. DiAguardi is dead. DiAguardi is dead. This doesn't say, hey, Dan, how are you? Or, Judge, how you doing? He just says, DiAguardi is dead. Now, I hear DiAguardi is dead, and I'm thinking of a person. A person died, right? I'm thinking of Joe DiAguardi died. Now, some of you know who Joe DiAguardi is, or know that he's a former congressman. So I'm thinking that somebody died, and that he's so happy about this fella DiAguardi dying. I say, I know Jay for 30 years. He can't be happy because somebody died. And then it realized all this went on in about 5 or 10 seconds, or 5 seconds, just through my mind. And then I realized he's talking about the DiAguardi case. He was so happy that DiAguardi died. The case had died. No more special circumstances being required. And he said that we had put an end to it. So that was in May of 2010, and it was at the Westchester County Bar Association that we agreed that DiAguardi was dead. Now, not Joe DiAguardi, but the case from the second department. Now, that was in the Cooper case in 2010, and we looked at the statute, and we made this distinction between party and non-party witnesses and felt that there was something more that was necessary because of the language and the way the statute was written and how it was amended. And as I said, the second and third department cases, the first and fourth department cases had a different view of that. Then 3 weeks ago, the Koch case comes along. That case is in your material, and Koch was decided by the Court of Appeals, and I'd like to just read from you a quote from Koch. Now, it may just set the stage a little bit. In Koch, the court is saying that under A4, non-party witness, there has to be notice. There has to be, on the subpoena, the notice that, or in a separate notice that the reasons or the circumstances of why you're seeking this disclosure from a non-party witness. But that's all that's needed. And the Court of Appeals states the words, quote, material and necessary. Now, again, material and necessary is in the opening paragraph. As used in Section 3101, must, quote, be interpreted liberally to require disclosure upon request of any facts bearing on the controversy which will assist preparation for trial by sharpening the issues and reducing delay and prolixity. Section 3101A4 imposes no requirement that the subpoenaing party demonstrate that it cannot obtain the requested disclosure from any other source. Thus, so long as the disclosure sought is relevant to the prosecution or defense of an action, it must be provided by the non-party. And that's Koch saying just that it's mere, material, and necessary, and that will be sufficient to satisfy the burden in order to obtain disclosure from a non-party. Now, after this case was decided 3 weeks ago, I sent an email to Jay on April 9th.
Your Honor, do you think you could speak more directly into the mic?
Oh, I'm sorry. It doesn't seem to be? Oh, geez. I am so sorry. Could you hear when I quoted the case? Do you want me to read it again, or do you have the material, right? I'm sorry about that. let's see.
Like Johnny Carson. It's fine.
Okay. So I sent an email. That's better now. I can hear it now. I'm sorry about that. The Koch case was a quote dealing with the material and necessary. That's sufficient. Nothing more is required. So after that case, I sent an email to Professor Carlisle, and I start by saying, Diaguardi is dead, really dead now. There's no doubt about it. You could put a bunch of nails in Diaguardi, and it's not coming back. This Court of Appeals has spoken, and they're the last word, as we know, and they have decided that nothing more is necessary. Now, Koch is a commercial case dealing with 5 bottles of wine, alleged counterfeit wine, fraud claim. Cooper was a matrimonial case. And I have to tell you that because it was a matrimonial case, that influenced the thinking of the judges. Because in Cooper, we had the husband suing the wife for divorce. The subpoenas were, 5 subpoenas were issued for bank records. There was a conference with the judge, discovery conference, where a timetable was set out when certain discovery would be disclosed, when depositions would be taken. The normal discovery material would be handed over. And before those deadlines were met, the lawyer for the wife dropped 5 subpoenas on these banks, these non-party witnesses. And 3 of the banks complied with 27,000 pages of documents. 27,000 pages. But there were 2 banks that hadn't yet provided the material. The husband moves to quash those subpoenas. The Supreme Court grants the motion to quash. We affirmed. Now, the thinking was that there should be a distinction between party and non-party, and that the trial judge, especially in a matrimonial case, is the best person to manage the discovery and the best person to see whether or not a lawyer is just harassing the other side or not. And that was the thinking of the court and why we felt a little bit more than just relevance, a little bit more than material and necessary would be appropriate or required. But the Court of Appeals didn't see it that way. But of course, they were dealing with a commercial case with 5 bottles of wine. I'm just wondering how they would have dealt if they had actually the Cooper case that had gone up on appeal. Maybe it would have been a little bit different, but that's not the situation. So we have the Koch case moving forward. And in Koch, in the opening paragraph of that case, there are 3 steps involved. And the first step is that the party that issues the subpoena must set forth the circumstances or reasons on the subpoena. Then the second, the witness in moving to quash must establish either the discovery sought is utterly irrelevant to the action, or that the futility of the process to uncover anything legitimate is inevitable or obvious. And then the third, the burden then shifts to the subpoenaing party must then establish that the discovery sought is material and necessary, that is relevant. So the mere relevance, material and necessary, is all that's required. We felt, when you look at the statute, the opening paragraph talks about material and necessary. Paragraph 4 interjects a new term, circumstances or reasons. If the legislature intended for them not to be anything more, they could have just as easily just said material and necessary in paragraph 4, but they didn't. They injected these circumstances or reasons. And I'm trying to explain to you as to why the court, that is the appellate division, felt that something a little bit more was necessary. But that's not the situation any longer. We're moving forward now, as of the last 3 weeks, that whether it's a party or non-party, as long as you're subpoenaing someone and it's relevant, not utterly irrelevant, but relevant, then you're going to be successful in defending a motion to quash. And you'll be successful in obtaining disclosure from a non-party witness. One final note, and that is in Cooper, we also said, as a matter of policy, non-parties ordinarily should not be burdened with responding to subpoenas for lawsuits in which they have no stake or interest unless the particular circumstances of the case require their involvement. So that's another reason why we felt there should be this distinction between a party and a non-party. So I think I've taken my 15 or 20 minutes. I'm going to now pass it back to Professor Carlisle. Thank you.
Thank you, Judge.